And greetings. Welcome everyone to Truth in Lending Act. We're going to do a brief review of this act. It's known in the short title as the Truth in Lending Act, but it's actually a title from the Consumer Credit Protection Act, which we're about to go over now. There's going to be some definitions. There's going to be a few other aspects to here that we want to definitely cover. And if you just stay with me, you're going to have some definite aha moments within this because it definitely has some interesting elements to it. Give me one moment while I get the everything in line here. Here we go. Interact. Okay, let's get this zoomed in a little bit so we can see what's going on. All right, so we're going over the Consumer Credit Protection Act. Again, we're looking at the most, this is the documents at large from the government's website. The Consumer Credit Protection Act is an act to safeguard the consumer in connection with the utilization of credit by requiring full disclosure of the terms and conditions of finance charges in credit transactions or in offers to extend credit and for other purposes. So we have here the whole chronology of this here. And the latest one we're looking at, I think, is 1978. Yeah, here we go. So Title 1 is what we're going to be going over first here, and this is the Consumer Credit Cost Disclosure. So let's go over this right away here. Just try and cut to the parts that are going to be most relevant so we're not blown over by all these black squiggly lines known as words. All right, here we go. Title 1, Consumer Credit Cost Disclosure. General Provisions. Short title under 82 Statute 146. You can look this one up, but of course that on those websites are usually just prima facie. This is going to be the actual document we're reading tonight. This title may be cited as the Truth in Lending Act. Section 102, Findings and Declarations of Purpose. So that's that there. Congress finds that the economic stabilization would be enhanced and the competition among the various financial institutions and other firms engaged in the extension of consumer credit would be strengthened by the informed use of credit. And that's what we're doing this here for tonight. If anyone's in there, please hit the thumbs up or give a heads up for me to know that the audio is coming loud and clear here on YouTube. And we'll be able to proceed from here, knowing that everyone's able to hear. The informed use of credit results from an awareness of the cost thereof by consumers. It is the purpose of this title to assure a meaningful disclosure of credit terms so that the consumer will be able to compare more readily the various credit terms available to him and avoid the uninformed use of credit, and to protect the consumer against inaccurate and unfair credit billing and credit card practices. I want to point out the use of the word him or her, but this is referring to a natural person here. All right, thanks, Moms Dukes. Good to know. And let's continue. Congress also finds that there has been a recent trend towards leasing automobiles and other durable goods for consumer use as an alternative to installment credit sales, and that these leases have been offered without adequate cost disclosures. It is the purpose of this title to assure a meaningful disclosure of terms and leases of personal property. Listen to this, for personal, family, or household purposes, so as to enable the leasee to compare more readily the various lease terms available to him, limit balloon payments in consumer leasing, enable comparison of lease terms with credit terms where appropriate, and to assure meaningful and accurate disclosures of lease terms in advertisements. So a lot of this language here you can tell is a bit dated, but it still applies. So now we're on to the good part here, Section 103, the definitions and rules of construction. So no one else is going to be able to interpret beyond these rules of construction here. So listen carefully. The definitions and rules of construction set forth in this section are applicable for the purposes of this title. The term board refers to the Board of Governors of the Federal Reserve System. So this is a private entity. The term organization means a corporation, government or governmental subdivision or agency, trust, estate, partnership, we'll come back to this, cooperative, or association. As private associations, clubs, partnership is when two or more, or really this is when you have people who are to a debtor, to defer payment of a debt or to incur debt and defer its payment. This is an interesting one too, or defer payment of a debt or to incur debt and defer its payment. Something to think about here. The term creditor refers only to creditors who regularly extend or arrange for the extension of credit, which is payable by agreement in more than 4 installments, or for which the payment of a finance charge is or may be required, whether in connection with loans, sales, or property of services, or otherwise. For the purposes of the requirements imposed under Chapter 4 and Sections 127A of Chapter 2, the term creditor shall also include card issuers, whether or not the amount due is payable by agreement in more than 4 installments, or the payment of a finance charge is or may be required. And the board, remember that's the Federal Reserve Board of Governors, shall by regulation apply these requirements to such card issuers, to the extent appropriate, even though the requirements are by their terms applicable only to creditors offering open-end credit plans. The provision of this title apply to any such creditor, irrespective of his or its, notice it's his or its, that's not his or her, that's his as a natural person or its as any other organization, status as a natural person or any type of organization. Okay, G, the term credit sale. Are you guys familiar with credit sale? Refers to any sale with respect to which credit is extended or arranged by the seller. The term includes any contract in the form of a bailment or lease if the bailee or leasee contracts to pay as compensation for use a sum substantially equivalent to or in excess of the aggregate value of the property and services involved. And it is agreed that the bailee or leasee will become, or for no other or a nominal consideration, has the option to become the owner of the property upon full compliance with his obligations under the contract. All right, so that's a big mouthful. Yes, sir. Captain Jack, we are live, so pay attention. This is going to be good stuff. I'm sure everyone's going to have a great matrix. We're going to have a aha moments throughout this because there's a lot of nice tidbits that have conveniently been overlooked. And I think once we go through this, a lot of the other instructions, things like that we encountered in YouTube lands will make a lot more sense. Now we have these under our belt. And Audit Them is in the house. Welcome. Make sure you catch his videos on his channel, which are remarkable. And let's continue from here. H, the adjective. Wait a second. Consumer is an adjective? So consumer is not a noun. The adjective consumer, used with reference to a credit transaction, characterizes the transaction as one in which the party to whom credit is offered or extended is a natural person, and the money, property, or services which are the subject of the transaction are primarily, listen to this, for personal, family, household, or agricultural purposes. Let's break this down, guys, because this is subsection H here. Elucidates a lot of things here. First of all, when we use the word consumer for this title, it's an adjective, and it's used with reference to a transaction, consumer credit, consumer loans, characterizes the transaction as one in which the party to whom credit is offered or extended is a natural person. So this isn't going to an organization, a corporation. This is going to a natural person because the services which are the subject of the transaction are primarily for personal, which would be a natural person, family, which only natural people have, and households, of course, or agricultural purposes. So if you grow, everybody, this is not to be construed as legal lawful advice, not for professional or personal use, anything outside the use of this educational entertainment broadcast. Don't do this at home. All right, let's continue. The term open-end credit plan. Open-end credit plan refers to a plan describing the terms of credit transactions which be made thereunder from time to time and under the terms of which a finance charge may be computed on the outstanding unpaid balance from time to time thereunder. Sounds like revolving credit type of thing. The term adequate notice, as used in section 1643 of this title, means a printed notice to a cardholder which sets forth the pertinent facts clearly and conspicuously so that a person against whom it is to operate could reasonably be expected to have noticed it and understood its meaning. Such notice may be given to a card holder by printing the notice on any credit card or on each periodic statement of account issued to the cardholder, or by any other means reasonably assuring the receipt thereof by the cardholder. So credit cards we're talking about here. The term credit card means any card, plate, coupon book, or other credit device existing for the purpose of obtaining money, property, labor, or services on the credit. The term accepted credit card means any credit card which the cardholder has requested and received, or has signed, or has used, or authorized another to use for the purposes of obtaining money, property, labor, or services on credit. We haven't really got over to money yet, but we're going to be getting onto that soon. The term cardholder means any person to whom a credit card is issued, or any person who has agreed with the card issuer to pay obligations arising from the issuance of a credit card to another person. The term card issuer means any person who issues a credit card. See, now we're talking about person could be an organization or a natural person. Okay, so the term card issuer means any person who issues a credit card or the agent of such person with respect to such card. The term unauthorized use, as used in the section 1643 of this title, means a use of the credit card by a person other than the cardholder who does not have actual, implied, or apparent authority for such use and from which the cardholder receives no benefit. The term discount is used in section 167, means a reduction made from the regular price. The term discount, as used in section 167, shall not mean a surcharge. The term surcharge, as used in section 103 and section 167, means any means of increasing the regular price to a cardholder, which is not imposed upon customers by paying cash, check, or similar means. So that's the surcharge, is the extra charge beyond cash or check or similar means. Interesting here, huh? The term state refers to any state, the Commonwealth of Puerto Rico, the District of Columbia, or any territory or possession of the United States. Any reference to any requirement imposed under this title or any provision thereof includes reference to the regulations of the board, that's the board, Federal Reserve Board of Governors, under this title or the provision thereof in question. So do you see this? Imposed under this title or any provision includes reference to the regulations of the Federal Reserve Board of Governors under this title or the provision thereof in question. Interesting here. The disclosure of an amount or percentage which is greater than the amount or percentage required to be disclosed under this title does not in itself constitute a violation. All right, just lost stream for a second. If we're back, just let me know. I want to get right down to this part here. All right, so we have the determination of finance charge, and of course, these are going to be referred to the 82 Statute 148 and 15 USC 1605. Let's see here. So this is how they're calculating life, incident, health insurance charges. So the footnotes are going to help us: liability insurance charges, exemptions. So I want to get back to the essence of this because we should all be reading this in its entirety at some point. Escrows, appraisal fees, and I really want to get section 121. So let's just keep moving down the line here. If there's anything here that catches anyone's eye that you'd want me to stop and elaborate on, I'd be happy to. But I really want to get down to section 121. I'm scrolling through here so everyone gets a little chance to see. This is a good one here, section 112. Penalties inapplicable to governmental agencies. Right? No civil or criminal penalty provided under this title for any violation thereof may be imposed upon the United States or any agency thereof, or upon any state or political subdivision thereof, or any agency of any state or political subdivision. So we're not using this for criminal penalties, let's just say. But this is not there necessarily for them. This is there to protect us, the people. All right, so we got reports, liability of assignees, and here we go. Chapter 2, the credit transactions. This is the good part here. So section 121, general requirement of disclosure. Now pay attention. This is the good part here because this is our Truth in Lending Act statements here, right? Each creditor shall disclose clearly and conspicuously in accordance with the regulations of the board, the Federal Reserve Board of Governors, to each person to whom consumer credit is extended. Remember, these are going to be natural persons in this case because we're talking about consumer. The adjective credit noun is extended. The information required under this chapter or chapter 4. So this needs to be disclosed. If there is more than one obligor, a creditor need not furnish a statement of information required under this chapter 4 to more than one of them. And what was repealed here, let's see. It's not there because it's been repealed. Okay, so we're on to 122. Form of disclosure. Regulations of the board, that's the Federal Reserve Board of Governors, need not require that disclosures pursuant to this chapter or chapter 4 may be made in the order set forth in this chapter or chapter 4, and may permit the use of terminology different from that employed in this chapter or chapter 4 if it conveys substantially the same meaning. Any creditor may supply additional information or explanations with any disclosures required under this chapter or chapter 4. So they may supply additional information or explanations, but not required. Exemption for state-regulated transactions. The board shall be regulated by regulation. The board shall, by regulation, exempt from the requirements of this chapter any class of credit transactions within any state if it determines that under the law of that state, the class of transactions is subject to requirements substantially similar to those imposed under this chapter, and that there is adequate provision for enforcement. Okay, so this is kind of where the exemption for state-regulated transactions, if the class of transactions is subject to requirements substantially similar to those, and that there's adequate provision for enforcement. So I guess in this case, state-regulated transactions may exempt the board, may exempt certain transactions if the state regulations, and that's where you'll see a lot of the statutes have to be modeled along this act. And if they are, then pretty much that's what's going to be used in courts, whereas they still have to follow the letter of this document here and at least, substantially similar to it. So, effect of the subsequent occurrence. If information disclosed in Okay, I think we're back. Let me know if we're back. It seems we jeez. Okay, are we back, everybody? Let me know in the chat. Seems that we are. I just want to make sure we didn't lose everyone in the process. Okay, let's see. If I'm still working here. Okay, anyone still there? Jeez. Okay, so we got people here still. I'm not sure if anything's showing up on the screen here from the chat. I have to refresh that stuff, it looks like. All right, guys, we're going to continue on here. If anyone's still here. Jeez. I guess this stuff's a little sensitive here. All right, I'll try and get that off. There we go. All right, we're all back. Okay, I lost my chat thing over here, so I can't overlay you guys' chats right yet. All right, we're just going to have to deal with it then. Okay, we're on section 124, the effect of subsequent occurrence. Let's see here. Give me a moment, guys. I need to try and get this thing fully up and running here. The heck? Okay. If information disclosed in accordance with this chapter is subsequently rendered inaccurate by the result of any act, occurrence, or agreement subsequent to the delivery of the required disclosures, the inaccuracy resulting therefrom does not constitute a violation of this chapter. So if things changed after the delivery of the required disclosures, those inaccuracies do not constitute a violation of this chapter. However, we'll see if there's anything else that might be in violation. Okay, this thing's acting real strange. Okay, I think we're going on now. Section 125, the right of rescission to certain transactions, except as otherwise provided in this section in the case of any consumer credit transaction in which a security interest, including any such interest arising by operation of law, is or will be retained or acquired in any real property which is used or expected to be used as the residence of the person to whom credit is extended. The obligor shall have the right to rescind the transaction until midnight of the third business day following the consummation of the transaction or the delivery of the disclosures required under this section and all other material disclosures required under this chapter, whichever is later, by notifying the creditor in accordance with the regulations of the board, that's the Federal Reserve Board of Governors, of his intention to do so. The creditor shall clearly and conspicuously disclose, in accordance with regulations of the board, to any obligor in a transaction subject to this section the rights of the obligor under this section. The creditor shall also provide, in accordance with regulations of the board, an adequate opportunity to the obligor to exercise his right to rescind any transaction subject to this section. Let's look at this here again, because that was a lot there. Except as otherwise provided in the case of any consumer credit transaction which a security interest, including any such interest arising by operation of law, is or will be retained or acquired in any real property which is used or expected to be used as a residence of the person to whom credit is extended. The obligor shall have the right to rescind the transaction until midnight of the third business day. So they try to word this in such a way so it's hard to understand, of course. But it seems to me that what this is saying here is that the credit transaction with a secured interest, right, that the obligor, the person getting that credit, could rescind it within 3 business days. But they put in things like residence, which is a commercial term, and real property, which is another one too. Real property. So these are commercial terms. They're not what they appear to be here. And clearly this, we'd have to go back and look at the definitions of these within the context of this. But I just want to get over that really quick here because this is a lot to unpack. Not liable for finance charge. So this is rescinding the contract within 3 business days. So these are technicalities here again for when it's done. So let's see what we got here. This is 10 days after receipt of rescission. Okay, so let's get past this here. Make sure I'm not skipping anything pertinent to the topics we're doing here. I don't think so. Okay. Content of periodic statements. If a creditor transmits periodic statements in connection with any extension of consumer credit, other than under an open-end consumer credit plan, that each of those statements shall set forth of the following items: the annual percentage rate, date or period which any payment must be made in order to avoid additional finance charges. Such of the items set forth in Section 127B as the board may, by regulation, require as appropriate to the terms and conditions under which the extension of credit in question is made. We have open-ended credit plans here. Conditions, I don't want to get too redundant here because there's a lot of things. The methods determining the balance, method determining the amount of the finance charge. So these are all in here. And I want to get down here to this, some other important parts here because there's a lot to unpack here again. And the more people that read more of this on their own time, as certain sections may apply more specifically to you, the ones I'm going over tonight are really the ones that should be generally applying to anyone involved with credit transactions. Okay, so let's see here. Sales not under open-end credit plans. In connection with each consumer credit sale not under an open-end credit plan, the creditor shall disclose each of the following items, which is applicable. Okay, the cash price of the property or service purchased. This is in your Truth in Lending Acts. The sum of any amounts credited as down payment, including any trade-in. The difference between the amount referred to in paragraph 1 and the amount referred to in paragraph 2. So some simple math here. All other charges individually itemized, which are included in the amount of the credit extended, but which are not part of the finance charge. So all their other little the extra charges they want to throw in there. But that has to be in that Truth in Lending Act. The total amount to be financed, the sum of the money described in paragraph 3, plus the amount described in paragraph 4. So that's the total amount financed, except in the case of a sale of a dwelling. The amount of the finance charge, which may be in whole or in part, be designated as a time price differential or any similar term to the extent applicable. A time price differential. Okay? The finance charge expressed as an annual percentage rate in the case of a finance charge, which does not exceed $5 and is applicable to the amount financed not exceed $75. Okay, yeah. Which does not exceed $7.50. Okay. The amount, due dates, the default, delinquency, or similar charges. A description. Here we go now. Pay attention to this because it's probably one of the most important parts. And look how far we have to dig to find number 10 here. A description of any security interest held or to be retained or acquired by the creditor in connection with the extension of credit, and a clear identification of the property to which the security interest relates. Now, security interest. is basically what are they using to secure the loan, the collateral. So you have to be in possession of collateral before it can be considered security. So keep that in mind, the time factors here. Except as otherwise provided in this chapter, the disclosures required under subsection A shall be made before the credit is extended, okay, and may be made by disclosing the information in the contract or other evidence of indebtedness to be signed by the purchaser. If a creditor receives a purchase order by mail or telephone without personal solicitation, and the cash price and the deferred payment price, and the terms of financing, including the annual percentage rate, are set forth in the creditor's catalog or other printed materials distributed to the public, then the disclosures required under subsection A may be made at any time not later than the date of the first payment is due. So if they're advertising it, I guess then they have to restate it at the first payment due, not later than the first payment due, just to make sure, I guess. And if a consumer credit sale is one of a series of consumer credit sales transactions made pursuant to an agreement providing for the addition of the deferred payment price of that sale to an existing outstanding balance, and the person with whom the credit is extended has approved in writing both the annual percentage rates and the method of computing the finance charge or charges, and the creditor retains no security interest in any property to which he has received payments aggregate to the amount of the sales price, including finance charges attributable. Okay. Thereto, then the required disclosure requirement subsection for the particular sale may be made at any time. Okay, so this is timing again on the disclosure. So we can get past this here. You have consumer loans, important. Consumer loans, remember that's an adjective, consumer loans, not under open-end credit plans. So any creditor making a consumer loan or otherwise extending consumer credit in a transaction, which is neither a consumer credit sale nor under an open-end consumer credit plan, shall disclose each of the following items to the extent applicable. 1. The amount of credit which the obligor will have the actual use, or which is or will be paid to him for his account. Wait. Or other person on his behalf. His account? What account? On his account. Or another person on his behalf. Person. Okay, contemplate that for a second. 2. All charges individually itemized, which are included in the amount of credit extended, but which are not part of the finance charge. So we talked about that. Those little add-ons there. They have to be itemized. But think about this here for a second. The amount of credit which the obligor will have the actual use, or which is or will be paid to him, or for his account, or to another person on his behalf. Paid to another person on his behalf. It sounds like paying to someone making a sale, but what would it be secured with if it's not in the possession yet? It's the thing I'm trying to figure out here. The total amount to be financed, the sum of the amounts referred to in paragraphs 1 plus the amounts referred to in paragraphs 2. Remember, this is your principal, so to speak, and this is the total finance charge added onto it. So those two together is going to be the total amount for the loan, supposedly here. Except in the case of a loan secured by a first lien on a dwelling and made to finance the purchase of that dwelling, the amount of the finance charge. The finance charge expresses an annual percentage rate, except in the case of a finance charge, which does not exceed, okay. A creditor may not divide an extension of credit into 2 or more transactions to avoid the disclosure of an annual percentage rate pursuant. Okay, the number, amount, and due dates or periods of payment scheduled to repay the indebtedness. So you can't divide this up, the creditor. The default, delinquency, or similar charges payable in the event of late payments. Can't divide an extension of credit into 2 or more transactions to avoid disclosure pursuant to this paragraph. Okay, so the description of any security interest held or to be retained or acquired by the creditor in connection with the extension of credit, in a clear identification of the property to which security interest relates. So clear identification of the property to which security interest relates. This needs to be disclosed. Form and time of disclosures, disclosures, requests for extension of credit. Okay, we're going to get past some of these technical ones here and get back to the final parts here. We're coming to near the end of tonight's because we've been on for quite a while, and I'm lucky to not have been totally dropped off yet. All right. Section 130, civil liability, except as otherwise provided in this section. Any creditor who fails to comply with any requirement imposed under this chapter or chapter 4 or 5 of this title with respect to any person is liable to such person in an amount equal to the sum of any actual damage sustained by such person as a result of failure. In the case of an individual action, twice the amount of any finance charge in connection with the transaction. Or 2, in the case of an individual action relating to a consumer lease under Chapter 5 of this title, 25% of the total amount of monthly payments under the lease, except that the liability under this subparagraph shall not be less than $100 or greater than $1,000. Or B, in the case of a class action, such amount of the court, in the case of any successful action to enforce the foregoing liability, the costs of the action, together with a reasonable attorney's fees, as determined by the court. In determining the amount of reward in any class action, the court shall consider, we're not worried about the class actions here because this is more about individual creditors here and the consumer. And a creditor has no liability under this section for any failure to comply with any requirement imposed under this chapter or chapter 5 if within 15 days after discovering an error and prior to the institution of an action under this section or the receipt of written notice of error, the creditor notifies a person concerned with the error and makes whatever adjustments. Creditor may not be held liable in any action brought under this section for a violation of this title if the creditor shows by a preponderance of evidence, that's 50% plus 0.001, that a violation was not intentional and resulted from a bona fide error notwithstanding the maintenance of procedures reasonably adapted to avoid any such error. Of course, pattern and practice might keep them from claiming that. Any action which may be brought under this section against the original creditor in any credit transaction involving a security interest in real property may be maintained against any subsequent assignee of the original creditor, where the assignee and its subsidiaries or affiliates were in a continuing business relationship with the original creditor, either at the time the credit was extended or at the time of the assignment, unless the assignment was involuntary, or the assignee shows by a preponderance of evidence that it did not have a reasonable grounds to believe that the original creditor was engaged in violations of this chapter, and that it maintained procedures reasonably adapted to apprise it of the existence of any such violations. Well, gosh, that sounds like one hell of a loophole. Any action under this section may be brought in any United States District Court or in any other court of competent jurisdiction within 1 year from the date of the occurrence of the violation. No provision of this section, now this is only talking about this section here. No provision of this section or section 112 imposing any liability shall apply to any act done or omitted in good faith, in conformity with any rule, regulation, or interpretation thereof by the board, that's the Federal Reserve Board of Governors, or in conformity with any interpretation or approval by any official or employee of the Federal Reserve System duly authorized by the board to issue such interpretations or approvals under such procedures as the board may prescribe therefore, notwithstanding that after such act or omission has occurred, such rule, regulation, interpretation, or approval is amended, rescinded, or determined by judicial or other authority to be invalid for any reason. So, Federal Reserve System duly authorized by the board, Federal Reserve Board of Governors, issues such interpretations or approvals. The multiple failure to disclose any person, any information required under this chapter, right, is our pattern practice. Single account, single consumer, what will it do? Shall entitle the person to a single recovery under this section, but continued failure to disclose after recovery has been granted shall give rise to additional recoveries. A person may not take any action to offset any amount for which a creditor is potentially liable to such person under subsection A2 against any amount owing to such creditor by such person, unless the amount of the creditor's liability to such person has been determined by judgment of a court of competent jurisdiction. Let's think about this. We said U.S. District Court, so a court of competent jurisdiction must be some type of court that keeps records. so that it can be used for this case, right? In an action to which person was party. Written acknowledgement as proof of receipt. Let's see, issuance of credit cards. All right, so I think it's a good place to leave off. I wanted to get on to the main part of it was what was it? The non. All right, it's been long enough. So we weren't looking at the revolving credit or any of these types of issues here. We were looking at the secured credit and how they're going about this within the Truth of Lending Act to ensure that the law is being followed as far as disclosures go, and that means that the law is being followed as far as their actions go in relating to any kind of extension of consumer credit. Again, consumer, for the purposes of this act, is an adjective. So is consumer debt, consumer credit, consumer loans, etc. So that being said, I would like to thank everybody for staying with me through this reading here. The Truth in Lending Act is the power of the people to ensure that the Federal Reserve, the United States Treasury, and the banks all work for the same purpose of forwarding and progressing the American people and their economy. So let's look at it this way. The more we take control of this and the more we understand, the less our country slips into the unnecessary debt that we see accruing daily by the minute. So salute to you all for attending. I'll be on here no much longer, and I just want to encourage you to hit the like and subscribe to the channel and hit the notification so that when I do go live with these readings, you can be sure to be notified, attend, and contribute so that we can all learn on this together. And I salute you all, and to that I say peace out.